Okay, so we'll begin. Welcome to all of you to this panel on a human rights assessment of the Higher Education Freedom of Speech Bill, which is a recent bill being discussed in the United Kingdom and has very important implications both for free speech as well as academic freedom. This panel is part of the Bonavero Institute's Price Media Moot event series. And I especially want to welcome, therefore, the Moot teams, the coaches, and everybody else who's connected with the Moot to this event. For those of you who do not know about our Price Media Moot, this is a global Moot event that we hold annually on questions related to media law and media freedom around the world. And I'm just about to post a link in the chat room to those of you who are interested in finding out more about the Moot itself. As you might have just heard, we will be taking questions through the Q&A feature on Zoom. You should see the button in the lower right-hand side of your screen. So feel free to post a question at any point, and I will moderate it and pose them to the panelists in due course when we get to the Q&A. So it gives me great pleasure to invite our speaker and our discussant today. And I will introduce our speaker first, who is Tom Cross. Tom is a barrister at 11 KBW Chambers. He's practiced in a range of areas, but with an emphasis on public and human rights law in its broadest sense. And in particular, he's acted in many high-profile judicial review cases in recent years. Some of you would have known of the Gina Miller case, which is the Brexit Article 50 case. He was involved in that. Lockdown, and many others. And he's been described in one of the main legal directories as, and I quote, the standout junior at the public law bar. He's also, higher education sector is one of the areas of public law that he specializes in. So we are very privileged to hear his views today on this very controversial bill. And not least, Tom is also a visitor at the Bonavero Institute this term. So in some way, he is in-house to us in enlivening our community with his practical experience. Tom will speak to us for about 35 minutes on the bill, and he will be sharing a screen, following which we will have comments from Professor Arif Ahmed from the University of Cambridge, and I'll introduce him just before his comments. So over to you, Tom.
Taryn, thank you very much indeed. I want to cover three things in my contribution to this discussion. Firstly, briefly, I need to set out the current most relevant law. Secondly, I want to identify three particular tensions which I consider are arising for universities in connection with free speech. And then against that background, I'd like to identify and try to make some assessment of the key provisions of the new bill, with an emphasis on answering the question whether this bill will improve or undermine free speech in universities. Just as the spoiler alert, for the reasons I'll explain, my view is that a number of the aspects of this bill ought to be welcomed by those who believe in the human right to free speech. But I think that there is at least a reasonable argument that the extent of the enforcement mechanisms, which I'll describe in due course, proposed by the bill, may have some unintended adverse consequences for free speech. And that's one of the things the government may wish to think about as the bill continues to proceed through Parliament. And I also think that in relation specifically to the definition of academic freedom in the bill, the government may be making an unintended mistake. I'm going to share my screen to just show, for those who are unfamiliar with them, the key provisions of the existing statute. Taryn, I hope that's come up on the screen for you. The current relevant law to set all of this in context is mostly contained in section 43 of the Education No. 2 Act 1986, that needs to be read together, and I'll come back to this with Article 10, of course, of the European Convention on Human Rights. And the main duty you see on the slide, the duty under subsection 1 of section 43, places a duty on every individual and body of persons concerned in the government of universities to take such steps as are reasonably practicable to ensure that freedom of speech within the law is secured for, and then 4 categories: members, students, and employees of the establishment, and for visiting speakers. Subsection 2 of the current law goes on to clarify, as it were, as a subset of that overall duty, that it includes the duty to ensure that the use of any premises of the establishment isn't denied to individuals or bodies because of beliefs or views. And together, those subsections can be thought of as the secure duty. When I talk about the secure duty, that's what I mean, the duty to take reasonably practicable steps to secure freedom of speech in those ways. We also have at the moment subsection 3 in the existing law. This is a procedural duty about a code of practice. So the governing body has to issue and keep up to date the code of practice, setting out procedures to be followed in connection with the organisation of meetings and other activities on the premises, conduct required of members, students and employees, and dealing with such other matters as the governing body considers appropriate. And there's a subsection 4 that's not on the slide that says that the way that ties in is that you need to take reasonably practicable steps to secure that the requirements of the code are complied with. So that's, as it were, the code duty that sits alongside the secure duty that we have. And the final slide to show you on the current statute, the current main statute, which is important, is subsection 8, which is about student unions. So where a student union occupies premises which are not university premises, the duty, the secure duty that I described earlier, still applies to the governing body in relation to those non-university premises. So student university, non-university premises are covered, but there is no liability on a student union. The liability, the duty is on the governing body itself. So that's a whistle-stop tour through the current existing statutory provisions. And before I look at the changes to that position, I want, as I say, to identify 3 particular tensions, which in my experience are being, this is my experience from cases in practice, either are being or certainly may be experienced by universities in relation to free speech. And the first tension is, I think that there is a tension between a desire to prohibit undesirable speech and the desire to prohibit unlawful speech. Take, for example, this policy, which is currently promulgated by a well-known university. I'm not going to name it. Academic freedom is no excuse for hate incidents. And then the policy goes on to define a hate incident as an incident which is perceived by the victim or any other person to be motivated by prejudice based on a person's protected characteristics, race, sex, sexual orientation, and so on. There's a tension here because in the UK, of course, saying something is not against the law by reason only of the fact that another person perceives it to be motivated by a prejudice based on a person's protected characteristic. You need more than just the subjective perception of the complainant. So suppose applying this policy that an academic makes criticism of the human rights record of the Chinese state. If a Chinese student, or indeed any person, doesn't need to be a Chinese student, perceived that to be motivated by a prejudice based on their race, nationality being an aspect of race under the Equality Act, it would, without more, on the above definition, amount to a hate incident. But that perception alone wouldn't make the speech unlawful. So the university that enters the terrain of undesirable but lawful speech can get into difficulty. And policies like those, in my experience from practice, are not uncommon in universities or student unions. But I do think they're likely to be unlawful having regard to section 43. That's because although at least some so-called hate incidents will be lawful speech, the university or the union under that policy isn't prepared to take any steps to secure the speech. And section 43 at the moment doesn't, of course, require all lawful speech to be permitted, its language recognises, because of the concept of reasonably practicable steps I showed on the first slide, that sometimes an interest in preventing even lawful speech may outweigh that in securing it. But it doesn't, in my view, allow a university to prohibit lawful speech without at least considering what steps might be taken to try and secure it first. And indeed, and this is where Article 10 fits in, when they are deciding whether to prohibit lawful speech because of Section 6 of the Human Rights Act, which will apply to the majority, perhaps not all, but the majority of higher education providers, they will have to ensure that they act compatibly with Article 10 rights. And Article 10, of course, permits prohibitions or limitations on free speech, but only where they are proportionate, proportionately in pursuit of a legitimate aim. So prohibiting speech on the ground only of the perception, this is an example, only on the perception of the listener without regard to any objective standard may at least arguably be a disproportionate interference, irrespective of your aim. That's the first tension which is being experienced in my view. The second tension is between competing interests in determining whether speech is lawful speech. So there are, of course, a number of provisions of legislation or principles of the common law which outlaw particular speech. And what they often have in common is the need to consider the reasonableness of the speech on an objective basis, which usually requires a balancing of interests. So, for example, in the field of criminal law, the Public Order Act 1986 is the main criminal statute which may be relevant to speech at universities. Section 5 of that act, for example, says, I summarise, that there is an offence of using threatening or abusive words within the hearing of a person likely to be caused harassment, alarm or distress. But it is a defence for the accused to prove that their conduct was reasonable. So the statute in that example requires consideration of the reasonableness of the speech, considered objectively by the court, and not merely the effect of the speech on somebody. And in relation, of course, to a university, if I was thinking about that provision by way of example, that aspect of the provision, the requirement to consider reasonableness, allows for the educational context of speech to be taken into account, requiring the university to perform a balancing exercise. Now, of course, in this field, beyond the criminal law or the requirements of charity law, or indeed defamation law may conceivably be relevant, the provision by far most commonly considered in connection with this are the protections against discrimination and particularly harassment under the Equality Act 2010. This slide shows the core part of the definition of harassment. Under that act, under the Equality Act, a person harasses another if they engage in unwanted conduct, it's often easy to demonstrate, related to a relevant protected characteristic, age, sex, race, and so on, and the conduct has either the purpose of violating the other person's dignity or creating an environment for them which is of the nature described, or effect of one or both of those things. And where it isn't the speaker's purpose, there being purpose and effect, where it isn't the speaker's purpose to do either of those things, as is very frequently denied as the purpose, whether speech harasses will turn on whether it has the requisite effect. But the statute goes on to say in subsection 4 that in deciding whether it has the requisite effect, you've got to take into account, in addition to the perception of the would-be victim, as it were, both quotes the other circumstances of the case. And again, there's that word, whether it's reasonable for the conduct to have that effect. So just like in the criminal provision that I mentioned, speech isn't under the law unlawful simply because the object of that speech or somebody other than the speaker perceives that it violates their dignity or perceives it to create an environment of the relevant sort. There will only be harassment where balancing the importance of free speech against what may be its harmful effect, as it were, the speech is unjustified. The university has to balance. Now, none of this legal analysis is at all, or certainly especially complicated or controversial to state. But in practice, I think, the university faces at least two difficulties. First of all, the practical difficulty will quite often be difficult for a university to decide in the circumstances of a given case whether the speech at issue is unlawful. It requires a consideration of evidence. The legal forum in which Equality Act harassment, for example, is most commonly litigated is the Employment Tribunal. It's just the forum in which it comes up most often. And in those cases, the tribunal will form a view on the reasonableness of the speech by reference to witness statements, which may be multiple, often from a number of sources, and over a hearing which lasts a number of days. And it is difficult, if it is difficult, to determine whether harassment has occurred after the event, which is what an employment tribunal is doing in that circumstance, and as it often is difficult to do, it is of course all the more difficult for universities to predict in the future whether a speaker will harass in advance. The second point about this balancing of interests, and herein I rather suspect may lie some of the motivation for the new bill, is that the law's preference for considering speech objectively as part of a consideration of the situation may sit uncomfortably with the university's position as a business, reliant on, among other things, the confidence of its students. For the reasons I've explained, though, the law may positively require universities to resist student pressure, depending on the circumstances, not to invite or to disinvite or to no platform or to deplatform or to dismiss academics or others expressing socially unpopular and perhaps very socially unpopular views. So that's the second tension. The third tension is, I think that there is a tension between the protections of the law and the objectives of very valuable and important anti-discrimination social movements. It's often a justification for preventing particular speech is the need to avoid perpetuating harm to those groups who have faced or face particular disadvantage in society, the disadvantaged group. Some theories of hate speech, so-called, for example, are founded on that objective. See Jeremy Waldron's popular book, The Harm in Hate Speech, for example, where he says that the purposes of hate speech laws is to reassure members of a disadvantaged group of their position as persons equal to all others in society. And of course, social movements which seek to promote the cause of disadvantaged groups are obviously of first order importance in reducing discrimination against those groups. But, and here's the tension, as the historian and my colleague at the bar, David Renton, has correctly noted in support of his argument that the no platforming of everybody but true fascists is counter-beneficial for the left. I'm going to go into David's argument in his recent book, No Free Speech for Fascists. The point is that discrimination law in the UK is not concerned only with the protection of disadvantaged groups. It is concerned instead, the Equality Act, and I'm summarising here, with avoiding the disadvantageous treatment of persons related to particular aspects of their identity, the so-called protected characteristics in the Equality Act. Of course, those characteristics are not limited to indicia of social disadvantage. Indeed, they may be indicia, the characteristics on which the claimant will rely, of social advantage or privilege. White people, men, those of the state religion, so on and so forth, are given their rights too. And one consequence of this for free speech is that when it comes to considering whether speech would harass the listener, it may also be necessary to consider whether a prohibition on it would breach the rights of the speaker. Take the case, for example, this may not require too much imagination, take the case, for example, of an employed academic who argues that sex is immutable, even when, let's say, it has been legally changed, and that trans women shouldn't be able to access female-only spaces. Suppose that students at the academic's university say that this is speech which amounts to the harassment of students with the protected characteristic of gender reassignment. Now, that group, the group with the protected characteristic of gender reassignment, is of course without question a most significantly disadvantaged social group, which has faced and continues to face major discrimination. But under the law, the fact of that disadvantage alone doesn't justify preventing the academic's speech. The key word there is alone. The university would also have to consider the protections afforded to the academic by the employment law provisions, in that case in the Equality Act, which prevent, among other things, the university from treating an employee less favourably because of their philosophical belief. And the protection for so-called, this example, gender critical belief, so-called, some people don't endorse the label, but I use it for convenience. The protection for so-called gender critical belief that was explained by the Employment Appeal Tribunal in the recent Forstater case. BAT held that provided it otherwise qualifies as a philosophical belief, warranting protection under the Equality Act, a belief which is offensive, shocking, or disturbing will still be protected, unless it would be an affront, I quote, an affront to the principles of the European Convention on Human Rights in a manner akin to that of pursuing totalitarianism or advocating Nazism or espousing violence and hatred in the gravest of forms. And on that basis, it found so-called gender critical beliefs to be not of that sort and therefore protected. So in my example, if the university were to subject the academic to a detriment because of her gender critical belief, including by restricting her speech, prima facie, it acts in breach of her rights. It would be committing direct belief discrimination. The fact that gender critical beliefs may run counter, therefore, to the objectives of a very important social movement seeking to promote trans rights is nothing to the point. So the tensions I've identified might be thought, I suppose, to illustrate the comparative ease with which universities acting with the best of intentions might fall foul of free speech law. They might also be thought by some to account for what may be regarded as an increasing free speech problem on campus, depending entirely on your perspective and your view of the evidence. But do tensions such as those or other risks to free speech warrant the legislation now proposed? What risk is there that the legislation could have the perverse effect, for example, of undermining free speech rights? Is the qualified human right to free speech well served by this bill or not? Well, let me attempt an answer by reference to the bill's provisions. And I should say, first of all, that the bill is still making its way through Parliament. It's been through the Public Bill Committee stage, but is yet to be reported to the House. So there's still the possibility, in other words, of further amendment, depending on which amendments are selected for debate in the first instance by the Speaker. The new legislation will, I'm going to stay on that slide and come on to academic freedom in a moment. The new legislation will enhance the protection currently existing under Section 43 in a number of ways, partly by substantively extending the current, what I called secure duty and code duty, but mostly, much more substantially, by introducing a wide range of enforcement mechanisms, principally in relation to those duties. I'm going to focus first on governing bodies, and then I'm going to come to another important part of the Act at this time at the end, namely student unions. So in terms of the substantive duties on governing bodies, well, first of all, the secure duty, take reasonably practical steps to secure freedom of speech for the four categories, currently in Section 43, will remain most essentially unaltered so far as it applies to governing bodies. There are one or two minor changes, but I haven't got time to go into them. Similarly, the code duty is currently, as currently framed, is essentially similar in the new bill, although such codes will now have to explicitly contain, I quote, the provider's values relating to freedom of speech and an explanation of how those values uphold freedom of speech. There's a bit added in, but essentially the code duty is similar. I want to particularly highlight two of the changes to the substantive duties on governing bodies. And the first is about academic freedom. So in the new legislation, unlike in the existing statute, the duty to secure free speech, the overall duty, is explicitly stated to include the protection of academic freedom so far as relating to academic staff. And it says that in relation to the academic staff at a particular university, this is defined to mean, on the current draft of the bill, as I put on the slide, their freedom within the law and within their field of expertise, A, to question and test received wisdom, and B, to put forward new ideas and controversial or unpopular opinions without placing themselves at risk of being adversely affected loss of job or privilege, likelihood of securing promotion. In relation to this particular provision, I think that the government has made an unintended mistake. What it presumably thinks it's doing is strengthening the free speech rights of academics as compared with the existing provision in section 43. It seems to me that when you construe the provisions of the new bill properly, that this change may have the opposite consequence. Currently, when courts would be called on, although they've been called on to do it rarely, to interpret section 43, the current law, it must do so consistently with Article 10 of the Convention, and Article 10 of the Convention as what Strasbourg calls a contextualizing factor, takes account of the position of academics when they are deploying or using their academic freedom. So there is a concept of, one can have an argument about its precise contours, but there is a concept of academic freedom already at large, as it were, in the jurisprudence of the Strasbourg Court, inbuilt in Article 10, which already forms part of statute law, because, not least because, section 43 needs to be interpreted in accordance with it. And importantly, in my view, on my reading of the Strasbourg cases, the Strasbourg enhanced protection for academic freedom is not limited to academic freedom in the way it's described in this bill. It applies a broader concept of academic freedom. For example, it's certainly not limited, in my view, to the academic acting within their field of expertise. That's clear, in my view, from a case called Kula and Turkey, K-U-L-A and Turkey, fairly recent 2018 case. That was a case where an academic had been reprimanded by his university for having spoken on a television program without permission, for various reasons, permission in order to speak outside of where he was geographically located. And the university had refused the permission to the academic because the university took the view that the topic he was going to be talking about was outside of his specialist field. And the academic complained that the reprimand was a breach of his Article 10 right. And there was no suggestion, and Strasbourg upheld his claim. And there was no suggestion in that the nature of the, as it were, enhanced Article 10 protection, taking account of academic freedom, is limited to where the academic is acting within their field of expertise. Strasbourg described the freedom in paragraph 38 as, I quote, freedom of expression and of action, freedom to disseminate information, and freedom to conduct research and distribute knowledge and truth without restriction. That's not the only example, by the way, of Strasbourg's regarding the concept of academic freedom more widely, I think, than is reflected in the current draft of this bill. There's another case, for example, called Sorguç in Turkey, S-O-R-G-U-C in Turkey, where it described academic freedom as including the freedom of an academic to express their opinion about the institution or system in which they work, which of course in most cases will be outside of their academic field of expertise. So as I construe the bill at the moment, the specific protection given to academic freedom as an aspect of freedom of speech is, I think, narrower than the academic freedom currently protected by section 43. And to that extent, I think this bill could be seen as unintentionally doing some moderate damage to academic freedom. Second point I wanted to make about governing bodies' substantive duties in terms of the change is to highlight that there is a new duty, government's made a lot of this, a new duty, not merely to take reasonably practicable steps to secure freedom of speech, but rather, or in addition, I should say, to promote what is described as, on the slide, the importance of freedom of speech within the law and academic freedom for academic staff. That's a duty placed on governing bodies. Now, the government's explicitly referred to this promote duty as directed at institutional culture. Legally, it seems to me to be a classic target duty, as public lawyers call it. In other words, it wouldn't give rise to an individually enforceable right in the court. The bill says that the Office for Students, the higher education regulator, will police compliance with this principally by requiring that the university's conditions of registration reflected. I have to say that in relation to decision-making in individual cases, this duty expressed at high level, I doubt, will add very much personally. It doesn't seem to me to prescribe any particular weight to be given to the speaker's interest in the balance. The duty is merely to promote, quotes, the importance of free speech, and that can still be done consistently with the prevention of free speech, providing, of course, that prevention that is consistent with the secure duty and Article 10. So those are the 2 points I wanted to make about governing bodies and enforcement. Governing bodies' substantive duty changes. In terms of enforcement, four significant changes for governing bodies. First of all, most of the enforcement will be via the OFS, the Office for Students. That is to have a new so-called director for freedom of speech and academic freedom who will be responsible for overseeing its free speech functions. Self-evidently, the identity of that person yet to be appointed will be important. The OFS has 3 main regulatory functions in relation to governing bodies. And I put on the slide them really in increasing order, as it were, of muscularity: the giving of advice, the adjudication of complaints under a new scheme, and registration conditions. So just saying something about each of those in turn: good practice or advice. So the OFS will have a power under the new legislation to, quote, identify good practice relating to the promotion of freedom of speech and academic freedom, and, quote, to give advice about such practice to universities. This, I have to say, seems to me a welcome and valuable power. As under the current law, this is difficult stuff. Universities are often called on to make difficult cases, fact-specific cases, in particular instances, including asking themselves, 1, is the speech lawful? And 2, if so, can it be prevented consistently with Section 43 and Article 10, often in advance of an event of concern? It's true that there already exists guidance published in 2019 by the Equality and Human Rights Commission. In my view, that's a very useful document, but the Equality and Human Rights Commission has no general remit, of course, in the education sector, and constantly has to decide in practice where to devote its resources. So my view would be that it is a clear improvement for best practice and advice to be provided by the body, which is now the principal university regulator, the OFS. So I think that's a good thing. The complaint scheme, the bill requires the OFS to provide a free speech complaint scheme under which it may be complained that a governing body has breached its secure duty. So the complaint is about compliance with the enforcement of the secure duty, where the complainant says that that's resulted in adverse consequences to somebody. Now, when you look at the shape of the bill, for those of you familiar with university complaints, the scheme that the bill sets out in a schedule is pretty similar in the way that it's shaped to that operated currently by the Office of the Independent Adjudicator for Higher Education, the OIA, which currently has a pretty wide jurisdiction over numbers of different types of complaints, including free speech complaints. But the OIA has a narrower jurisdiction than that contemplated here. Firstly, because the OIA is for students only. So if you're the academic member of staff, you don't go to the OIA. And secondly, because when you look at the way that the OIA operates under its scheme, it limits its consideration when it adjudicates on the complaint to considering whether the university has acted reasonably. So it applies a slightly more hands-off standard of review than I read the OFS being required to do in this case. So there's more here than just, as it were, a reproduction of the OIA's jurisdiction in relation to free speech hived off to the OFS. 2 brief points about the complaint scheme. First, I think it's difficult to object in principle to there being a forum for the resolution of disputes about the secure duty, which doesn't carry the formality or cost rules of formal courts proceedings. But the second point is that I do think that the government is currently missing an opportunity to foster greater confidence in the scheme by not requiring the decision maker at the OFS to be legally qualified, or at least to have to consult a qualified legal advisor. I say that because of the necessary involvement of the law. Is the speech lawful before you even get to whether or not it can be restricted compatibly with Section 43 and Article 10? These are inherently questions which will require some legal view to be taken of the position. I think that the bill will be improved by adding that in. Registration conditions, I'm going to say very little about. These are already familiar to universities. But I do want to come to the new tort which the bill will impose. This seems to me arguably the most controversial aspect of the bill. It allows, as you see from the slide, a person to bring civil proceedings against the university, also the union, in respect of a breach of its secure duties. Now, this certainly fills in a certain gap in existing liability. So a gap that isn't currently plugged by the employment protections, for example, of the Equality Act, or somebody who wants to get compensatory damages as distinct from the nominal or just satisfaction damages that they might get on a HRA claim for breach of Article 10. So you could go by way of HRA Article 10 claim, but you're not going to get compensatory damages. You're only going to get so-called just satisfaction damages. So it plugs a gap and it adds something. And I agree with those who pointed out that having to defend proceedings like these, if you're a university, will of course involve universities in certain irrecoverable costs. I agree that there must be some risk of unduly defensive decision-making to avoid that exposure, and that may be contrary to the promotion of varied speech. I just think that the main issue here for Parliament is whether the extent of, on the evidence, the free speech problem at universities is worth that burden and that potential risk. I'm going to very briefly, if I've got time, Taryn, in the last couple of minutes, say something very quickly on student unions. I don't want to leave out student unions entirely. It's an important part of the bill. I mentioned at the start that although student unions will often, of course, have their own legal personalities, Section 43 doesn't impose any liability on them at the moment, and this has led to difficulties. So most obviously, for example, the Section 43 duty may sometimes mean that the university itself, or those who are responsible for its governance, are liable for decisions of their student union, or a student or a body within the university which qualifies under the definition of a student union, which is broad, in which it's not necessarily involved. The university is not necessarily involved in that decision, but is liable for it. So what does the bill do? Well, first of all, it applies a very similar version of the secure duty to student unions. Secondly, they'll also have to have their own code of practice with similar requirements to those on governing bodies. Thirdly, in terms of enforcement, student unions now may, like governing bodies, be the subject of complaint to the OFS. And they too are subject to the potential liability under the new statutory tort for breach of their secure duty. Student unions, of course, have registration conditions like universities do, but the bill, as it were, seeks to make up for that by saying that the OFS can fine student unions if they're failing or have failed to comply with their secure duty or their code duty. So even more clearly in the case of student unions than I think in the case of governing bodies, the regulation is given bigger teeth. And just to wind up, Taryn, whatever view it seems to me one takes of the extent of the free speech problem on campus, and however much it may reflect the decisions of student unions specifically, such a problem, there must, I think, be a real concern here that the costs these measures will or may impose on unions are out of proportion to the mischief. And here also, I think there must therefore be some level of risk that the Act will have an unintended adverse consequence for free speech. The NUS gave evidence to the Public Bill Committee that since, as it put it, the routes for legal redress are open for speculative claim against students. Quotes, ironically, it's likely this will lead to fewer events, not more, as universities and students' unions seek to reduce their risk of litigation. It seems to me that in passing this legislation, that is one of the bigger risks, I think, that Parliament will take. Taryn, thanks very much.
Thanks for that fantastic tour of this bill, and I certainly know a lot more about it than any of the newspaper articles taught me. We have comments from Professor Arif Ahmed now. Arif is a professor of philosophy at Cambridge who writes mainly on decision theory and also has an interest in religion and has debated the subject against William Lane Craig, Rowan Williams, and others. He's an atheist and a libertarian, and his philosophical outlook is most closely associated with those of David Hume and Friedrich Hayek. Over to you, Arif, for about 15 minutes.
Thank you very much. Can you all hear me all right? Great, thank you. Thank you very much, Tom. That was a really enlightening and interesting talk, and you set out very clearly, as you say, some of the tensions and then some of the issues arising with the bill, which is seeking to address those tensions, which you rightly identify. I wanted to pick up on, well, I mean, there were 5 things that you discussed that I guess I especially wanted to pick up on. So I'll try and cover as many of them as I can in the time that I have. I may not cover all of them, and there may be questions have more interesting things to raise. So these are the points about, first of all, the definition of academic freedom. Second, what you call the duty, the promote duty, and quite what that amounts to. There was the issue about whether the Free Speech Director or the OFS itself should have legal advice with regards to the application of this bill. There was a point about, which you raised in 2 connections, in connection with GBs and in connection with student unions, to do with the sort of defensive decision making that you think there's a risk that this bill will create if it becomes law. And then finally, there was a point about the costs to student unions that it might impose. So a couple of those I'm only going to talk about briefly, namely the ones about legal advice and costs to student unions. But I do want to say a bit about, first of all, about the other 3. So starting with the point about academic freedom and the definition of academic freedom that's being used in the bill. Would you be so kind as to put that slide up on the screen again so we can all see it? Thank you. That's great. Thank you very much. So this is oh, thank you. Yeah, so this is academic freedom as it's specified in the bill. I should say, sorry, first of all, I'm not a lawyer, so I might make some mistakes about this. But this is just my sort of experience of how these issues are played out at universities as an academic. Within the law, within their field of expertise. So I agree with Tom's concern regarding the clause within their field of expertise, but for slightly different reasons. A couple of reasons. One of them is to do with the fact that a lot of the really interesting discussions in academia and a lot of the advances come when people are talking to one another about areas that is not in the field of expertise of at least one of them. So that if you have people across different disciplines, say economics and biology or something, you might get interesting advances in those areas because people are discussing topics that they might have in common, or at least one of them might not be speaking within their field of expertise. So you'd want to allow for those sorts of things to fall under the scope of the bill. The second issue I had with it just concerned the fact that I want to talk about the conduct of my own university without fair reprisals. And it's not in my field of expertise that Cambridge University is giving all this money to China, but I do want to be able to make a fuss about it and say why I think it's a bad idea without risking being sacked. So, there should be something to cover academics who might risk damaging the reputation of their employing institutions. On the point about the application of the Human Rights Act, of Article 10, I agree this is narrower than the definition that appears to apply in the case of Article 10. I wasn't sure, because I'm not a lawyer, whether this means that if this bill becomes law, we'll actually have fewer freedoms than we would have done otherwise, or whether it only means that because Article 10 will still apply, whether it only means that if it becomes law, we'll have fewer freedoms than we would have done if that phrase within their field of expertise had been scrapped. I think there is an amendment number 27, that arose in the Public Bill Committee, which the Minister has agreed to look at again, which is scrapping that clause. So I think there's some grounds for hope there, but I agree with Tom's points. Moving on to the promote duty. Okay, can you make it full screen now for me? Thanks. Moving on to the promote duty, I guess one thing I'd say there is that I was envisaging that as, so this is the duty to promote the importance of freedom of speech and academic freedom. So there are 2 things you're promoting. You're promoting the importance of freedom of speech and you're promoting academic freedom. I think the intention, as I understood it behind this, and I do support this, was indeed to accelerate discussions of these matters at every level within the university, and to make it something of a default with regards to what happens at decision making at various levels. So to give an example, with promoting of academic freedom, I could imagine this would work by, for instance, students being told at induction when they start, just as they're now told rightly about they're given workshops on consent, they're given training on all kinds of things to do with equality and discrimination. so too they could be given training on this. It needn't be long, but it's just good for students to have because they don't think about it and they don't get taught about it otherwise. And it's so important that they should. So this is one respect in which I think one could comply with the duty. Another respect, which I've mentioned myself, I think in the committee, was the importance of secret voting. So that, for instance, at many university committees or faculty committees, decisions are made by raising your hand. And that's fine with a lot of things, but with controversial things where you're making, you have a view on something, the person in your room who's your supervisor or superior has a different view. You can't freely express your own view on these matters. And they may be matters about syllabus, matters about policy and so on. You can't freely express those. So that would be a simple, administrative change that could count as an example of meeting what I think should be in the guidance. There are other things too, we could perhaps discuss those in the questions, but that's how I imagine the promote duty actually having application. And I think it could make a big difference because I can imagine, if we get to a stage where we routinely think about the free speech implications of decisions when we, at university committees, in just the ways we now routinely think about the equality and diversity implications of such decisions, I think that could have a big difference on our decision-making habits. So I think the promote duty is really important and really welcome, and I at least hope that it could make a big difference. On the point, I think I'll just take Tom's points in sort of chronological order, but on the point about legal advice for the OFS, or the OFS, the Free Speech Director ought to be legally qualified. I think that's perfectly sensible and correct. I believe the OFS Director herself made something like this point when she gave evidence to Parliament on it in September. So she said they will definitely have, just as the OFS, they have legal advice already. There's a well-qualified team of legal advisors that the Director would have at their disposal. On the point about defensive decision making, yeah. So this was something where I guess there's a couple of things. I mean, one thing is that the level at which the decisions are made in many cases is dissociated from the levels at which the risk is being borne, and therefore the scope for defensive decision making is perhaps limited. Let me give you a concrete example. Suppose I want to invite Jordan Peterson, or some other controversial speaker, say somebody who writes on race or something, to come and give a talk at Cambridge, and there's a risk there if this bill becomes law, but I'm not going to bear that risk. It's my university which might have to pay a fine. I personally would not have to pay a fine if that person was cancelled. So, and I'm the one who makes the invitation. So I, as an individual academic or as an individual society, if I'm a student, can say, right, we're going to invite this person. The bill itself stops the university from stopping me doing that. Stops the university from stopping me doing that. The bill has a provision which says they can't deny me premises on the grounds of the belief of this person. So the university can't stop it. They might worry about it. They might become neurotic, but they can't stop it. But they're the ones who would have to bear the cost if, as a result of this invitation, there was some breach. And so whilst I do agree that it places risks on universities, and they would have a problem with that, I don't think it's always, when I think about cases like that, invitations of speakers, it's not so clear to me that that's going to result in this kind of defensive decision making. Something similar applies to some extent with student unions, so that an individual student or an affiliated student society can invite a speaker, to come and talk on its premises. The student union can't stop them from doing that, as this bill says. And if the student union has to pay a fine as a result of some breach, that's a risk it's going to have to take. But it can't, so to speak, translate that risk aversion into defensive behavior at the point of invitation. There is a separate issue when it comes to the point of employment. So you might think this kind of defensive decision-making applies to whom you would employ, but the bill does have a specific provision for that. So it does rule out not employing someone on the grounds of their beliefs. So I think there should be more discussion about that. I think it's a very interesting issue, and there are other things to say about that. The last couple of things I'll say is to do with, actually, I'll say one more thing about defensive decision making, which is also that there are risks on both sides. So it's not that the only way to avoid risk is to prevent these things from happening. That kind of risk has to be balanced against the risk that will be borne by not employing someone whose views are controversial, or by not inviting someone, and the sorts of complaints that you could imagine universities getting in consequence of that. So, but that's perhaps the thing that concerns me the most, and the thing that I wanted to talk about the most. There was one other issue. So I talked about academic freedom, the duty to promote, the issue about legal advice, defensive decision making. So the fifth and final thing that I wanted to mention was the costs on student unions. And there I agree, and partly I agree that there's an issue, and part of the problem, comes from the enormous variation in size of student unions. So you might have really tiny colleges which have got student unions of 4 or 5 people, running it, or you might have something like in Cambridge, there's a huge student union that does a great deal and is doubtless much better resourced. All I can say is that at the moment, my impression is that that's a risk that the government is aware of, and they haven't yet written or even consulted upon the regulations which will determine what the levels of fines are that would be levied upon student unions that breach this. But I believe that the minister's intention is to consult with student unions as well as with the sector more broadly when it comes to formulating these regulations. So I think I can totally understand the risk, but I think it's one that the government's aware of, and that as the bill goes forward and as the regulations are drafted, it will be taken account of. So I think that's everything that I had to say for now. So thank you very much.
Well, thanks very much, Arif, for those fantastic comments. And before I invite you, Tom, to do a quick reply, I first want to remind the audiences that they are very welcome to post any questions in the Q&A box, and I'll post them to panelists on their behalf. And since there isn't a question, I'll just add one of mine to Arif's, and then Tom, I'll give you a minute or two to pick and choose whatever you want to reply to. So here is one of the difficulties at a more sort of broader rather than granular level with the bill is that there seems to be an implicit assumption that free speech and academic freedom pull in the same direction, or almost always pull in the same direction. And I'm not sure that that's true. So as academics, we are always denying or restricting expressive abilities of others. When I'm designing a syllabus, I'm leaving people out. When I'm inviting somebody for I'm not inviting many others. When I'm working as an editor in a journal, I'm deselecting pieces. In classrooms, I call upon students and sometimes ignore other hands for a variety of reasons, right? Admission of students, recruitment. So academic life, just by its nature, requires, in the jargon, deplatforming. And one of my worries is that the bill may be read as, especially given how the promoter duty is read, is not just as a duty to protect free speech, but a positive duty to provide a platform for expression. And that, I think, is a huge challenge to academic freedom, because academia by its nature is exclusive, and by its nature is excellence seeking. So any attempt to, free speech has always been a negative right, where in the public domain you can speak what you like, but there's no duty on anybody else to facilitate your speech. Right? And universities, by being public universities, when they're public, have this strange status of both being a public space, but also having this academic mission, right? So I think, and I'm just posting a link to everyone. We had a previous panel last term on the same topic where many people participated. It was a more broader level panel with Professor Adrian Stone from Melbourne, who's written a book recently on academic freedom, was making this point that the two rights are different and can often come in tension, can often pull apart. And she also talked about the things that this bill does not take into account, things like challenges from donors, challenges from other states, laws of other states. China has come up in conversation, and so on one level, this is not going far enough to protect academic freedom. I'm just wondering how you think about those issues. Do
you want me to answer that now, or shall I wait?
Just one more question. I'll throw it at. No, why don't you respond, Tom, and I'll wait for more Q&A questions to come up, because I don't want to overload you with too much. So take your time, And in audiences, again, I have one question in Q&A, but please post others and I'll post them to Tom and Arif.
So thanks, Darren. I suppose four comments to make, or themes to pick up on. I mean, firstly on the question raised by Arif as to whether or not the attempt to define academic freedom in the new legislation may result in a lesser or fewer freedom, putting to one side Taryn's point about the potential to separate out as different beasts, freedom of speech and academic freedom. My view is that there is a real risk that properly construed, the court would say that the full extent or the widest contour of the concept of academic freedom that I'm allowed to use when I enforce this legislation is that provided for in the definition. The legal argument would be along the lines of, why are you bothering putting in any definition of academic freedom, still less one that restricts academic freedom in the ways that it does. I mean, it's not obviously a wholly narrow definition of academic freedom. Obviously, still it will cover a large amount of stuff. But I do think that the court might reason, if this were challenged in an appropriate case, that you don't treat the provision as redundant, as a well-established principle of construction of legislation, and you give it meaning. And you cannot give the definition of academic freedom meaning without reducing the content of it in relation to the secure duty at large. There is a slight qualification to that I didn't really have time to develop in my talk, but I mentioned briefly now, which is that there are in fact two secure duties in the new legislation. There's the secure duty, which is the general one that I focused on, and which is expressly stated to include the definition of academic freedom that I mentioned. But there is also, and Arif touched on this, a specific further protection that is given to a person seeking to exercise their academic freedom in relation to applying for a new job. So it's an employment applicant based additional duty. And that of course is beyond what we've currently got, but which extends essentially the four categories and not to applicants. And there I would accept that if you're comparing the new bill as against the existing law, it is moving matters on further. It still uses the same definition of academic freedom, though, when you look at the provision on applicants, and the arguments can still be made that it is narrower than what Strasbourg would say academic freedom would mean if Strasbourg was looking at an applicant case. So the point still stands. It's just that the point of comparing, as it were, Strasbourg's approach to the definition in the statute still stands, but it's right to note that there is a more enhanced protection from that which is currently in UK statute law or in the 1986 Act. So that's the first thing. Second thing is I was interested in Arif's point about culture and mentioning, and this was, as he knows well, and those who've followed the passage of this bill knows well, a theme that has come up a lot. The idea that there is thought to be a tension between countervailing cultural objectives. So now universities and public authorities, quite rightly, not least because it's the law, have much more firmly in mind than they used to do when the Equality Act first came in my experience, that they need to think about the equality implications of what they're doing. Best example of that in the Equality Act, of course, is the public sector equality duty in section 149 of the Equality Act, which, although it's quite often misunderstood as a duty of outcome, it being instead a duty of process, a duty which requires you to think about the equality implications in various ways of what you're doing. And it will be interesting to see, I think is my observation, whether the higher level, because I think that's undoubtedly a correct characterization, the higher level provisions of this bill will lead universities and student unions to develop the same cultural practice that they have been forced to do when, for example, assuming they're a public authority, when section 149 has bitten on them. So I'm interested in public sector equality duty changing culture versus will this change culture. Thirdly, on defensive decision making and so on, of course, Many areas of the law, tort law generally, education law specifically, is no stranger to the public policy argument that if you impose an additional liability on somebody, it's going to mean that they're defensive in one way or the other. It was great. It's about 10, 15, more than that years ago, show my age, in the education field about whether you should impose duties of care in negligence on teachers when they teach in schools. Will the actual nature of the teaching, never mind discrimination or free speech, will the actual content of the teaching become more defensive in teaching practices because they're facing tortious liability and negligence? So that there may be some interesting point of compare and contrast there. But what I would say is, to the extent there is a risk, and there must always be some level of risk of these things, I do think that risk could be substantially reduced the more that the government can help this in amendments to the legislation if they can work, the more that they are able to get the university sector to have confidence in the OFS support and the support of any other bodies in connection with all of this. That is a mechanism that is already in the Act, because they can give good practice advice, the OFS, and there may be other ways, I don't know, in which that confidence could further be improved on the part of universities and unions. And the more confidence they have, because they have better quality policy, for example, guidance given, the less likely, I would have thought, in principle, any unduly defensive decision making is going to be. And just finally, on Taryn's point, I mean, there is a very interesting, I very much enjoyed Adrian Stone's presentation, which I recommend anybody to look at. Very interesting argument that conceptually academic freedom should be treated as this separate beast, not least because of the fact that it may pull in a different direction from freedom of speech for the reasons you've given. Under the law, however, in Article 10 of the Convention, which, unless Mr. Raab, according to the recent Conservative Party conference, or anybody else is going to have his way in terms of changing the Human Rights Act, all legislation will be required to be construed compatibly with, is that the fact is that Strasbourg does treat, rightly or wrongly, academic freedom as what it describes as a contextualizing factor in the context of free speech. I'm not aware, that may be an interesting piece of work to be done on it, but I'm not aware of the conceptual distinction, the merit of the conceptual distinction to which you refer being picked up in courts interpreting international human rights treaties like the Strasbourg Court. I'm not aware that they've done that, but I think there's an interesting question there to see whether any of these courts who are policing any of the relevant international human rights treaties which provide for freedom of expression are seeing it as a subset. There are, of course, provisions, which deal specifically with the nature of academic freedom. But there you have a separate provision in some sort of instrument, and it's only about academic freedom. It would be interesting to explore whether or not a provision about freedom of speech, which doesn't expressly refer to academic freedom, is prepared to look at it in a different way from Strasbourg. So there we are. There are some observations on your combined thoughts.
Thanks very much, Tom. There are two questions which I'll pose, and then I'll give both Tom and Arif the final word, because I believe we have to finish at 1:45. So, so Bryn Harris asks, and the question is, the OIA has been told by courts that it cannot determine legal rights and duties. Is there a danger that the OFS scheme will be told the same? And could this neuter the scheme's effectiveness? The second question is from John Adentiere. John asks, effectively, whether this is not an instance of the law taking sides in the free speech debate, because no platforming by student unions is itself an expressive act that it is a component of their right to free speech. And like you know, it's a form of protest, like all boycotts have always traditionally been treated as free speech rights. So when there is a clash here between the free speech rights of two parties, isn't it counterproductive? Isn't the law diminishing the right of student unions to their free speech by taking sides in this debate and privileging the speech rights of the person being deplatformed over the free speech right of the union. Yeah. So I think that those are the only questions we have. So maybe Tom, and then I'll come back to you, Arif.
Thanks, Sarah, and thanks for the questions. I mean, on the first point, I think the OFS has to, under the statute, determine legal rights, or at least legal responsibilities, legal duties, because it will be charged on the current wording of the bill with determining whether or not the secure duty, as I've summarised it, is breached. And that is, I agree with the questioner, a clear difference between the jurisdiction that they're given and the more hands-off jurisdiction that the OIA has under its scheme, and which the court has said it cannot go beyond. So it may be told that, and if one is advising it, it should be told that, because that's what the statute says. There is, of course, an issue as to whether or not it is right and proper for a body which is not a court to make an adjudication on the breach of the secure duty, which is what it will do. It's not going to be asking whether or not, like an ombudsman does, for example, there's been manifest unreasonableness or maladministration, or even some slightly more exacting mid-standard like the OIA, reasonableness, has it acted reasonably. It's doing more than that under the statute. And there's, of course, a policy question as to whether it's right that a body that isn't a court should do it. But that's precisely why, and I was interested to hear Arif agreeing, it seems to me that at the very least access to legal advice on the part of the OFS is important in these cases. It's not just for the reason I gave in my presentation that these decisions will necessarily involve thinking about what the law is. It's also because you are determining a legal right. You're not doing so, I should say, with binding remedy. That's a point that should be made clear to anybody who, because we haven't covered that yet, these are non-binding recommendations that the OFS is going to make. So you have a little bit of an odd fish in that you have a body who is determining, currently without access or requirement to take legal advice, legal rights, but it's not binding on the institution. There may, of course, be some tie-in with the OFS's separate function of requiring compliance with the substance of the secure duty and registration conditions. So there's a few observations about the first question. On right to protest, well, the government's been very clear in what it said in connection with this bill, that it is not seeking one iota to undermine the right to protest. If protest means that there is going to be a difficulty such that no reasonable steps can be taken to secure free speech, then of course the university is going to be entitled to not hold the event. The very little case law that there's been on the existing Section 43 duty has only been about that. There's really only two cases. There's an older case called Ex parte Caesar Gordon, which was about a decision by University of Liverpool not to have speakers who wish to come along to speak in relation to the question of apartheid in South Africa. And the view that was taken by the university authorities was, because we've been told by the police that there is going to be a breach of the peace, we are going to decide to withdraw the invitation to those two speakers. Now, the legal case in the end turned on quite a fine and narrow point, which is whether or not you're entitled, if you're the university, to take account of a threat of breach of the peace on premises that are outside of your control. So if the riot that your speaker is going to cause takes place in Birmingham and you're in the University of Oxford, should you be able to take account of that? And the court said, no, you must disregard legally, construing the statute, the riot in Birmingham. But if, however, activity is going to have some sort of impact on your own premises, then you're perfectly entitled to take account of it. So these considerations will come in, including that case law, if there's a protest. Where is the protest? How serious is the protest going to be? And are reasonable steps able to be taken, reasonably practical steps, I should say, able to be taken, which minimize the risk that may be posed by that protest. So the government's line is, and it seems to me broadly to fit within the statute, that one can have the two hand in hand, but it all goes to that all critical highly fact-specific decision by a university as to whether or not they can reasonably do more to stop trouble. I've taken too much time there. And
No.
What Arif
I think the
has to
question
say
was
about
that deplatforming itself is the protest and a form of speech. But as you say, well, let's hear from Arif, and then we'll have to close because.
Thanks so much. Yeah, I don't think I've got anything to add to Tom's remarks with respect to Bryn's question. But I will say something about your excellent question, Terry, and John's question. So with regards to your question, of course, it's true that there's a difference and sometimes a tension between academic freedom and freedom of speech. The promote duty distinguishes, as I read it, between promoting the importance of freedom of speech, which doesn't mean promoting free speech, it means promoting which is a kind of educational duty, if you like, and promoting academic freedom. So academic freedom is the first order duty that it promotes. The other thing is sort of educational. So I don't read that clause, that A3 clause, isn't it, which as having that consequence. With regards to the question of the sort of related issue about no platforming, I mean, I think you can distinguish between no platforming in the sense that a student or a society or a student body has a policy that it will never invite. It will never invite people who hold a certain view. Nothing in the bill will stop that. Because of course, as you say, that is a legitimate form of protest and they're free to do that. The bill is not against inviting, it's against disinviting. So if I invite someone, nobody can stop me from going to listen to him. People who don't like it don't have to listen, and they have a right of protest, but they don't have a right of veto. So they can't stop me from going to listen to this person, even if they don't want to hear that person themselves. So there's a distinction. How much that had to do with the motivations for the bill, I don't know. I don't know what the motivations were. But in terms of the aspects of it which I welcome, given my own experience in higher education, I think that's something that we should be moderately concerned about. And I think the bill does, goes some way towards addressing it.
Well, I think that brings us on the dot to 1:45, and this has been a fantastic conversation. There are clearly many unresolved issues, and the debate will continue. But I know that I have learned a lot more over the last hour and a half. So thank you very much to Tom and to Arif for this conversation. And we have recorded the event, and the recording should be posted on our website before. If you have any feedback, there are links in the chat box that we'll be very pleased to hear. Thank you all very much, and hopefully you will join us for our future events this term. Bye-bye.